Hello friend, this is Mike Trejo from Law School for Teens, and today we'd like to talk about the 5 legal rights that every teenager should know. Imagine this. You are sitting in your classroom and a police officer walks in, and as that police officer walks in, he calls your name. And so you go with the police officer down to the office. You're not sure what's going on, you're a little bit nervous, you're 13 years old, and you sit down in this room with this police officer and 3 other adults. No parents, no lawyer, and they start asking you questions. Just you and 4 adults staring at you. This actually happened, and this is a case that went all the way up to the Supreme Court. Today we're covering 5 legal rights that you have as a teenager right now. Most teenagers don't know that these exist. Let's get into it. Right number 1, what are the Miranda warnings? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney will be appointed to you. These are the Miranda warnings, and they come from a court case called Miranda v. Arizona from 1966. The idea is that if the police have you in custody and they're about to interrogate you, then they have to give you the Miranda warnings, which tell you about your 5th and 6th Amendment rights, the right to remain silent, which is the 5th Amendment, and the 6th Amendment, right to an attorney. They have to tell you those rights before they start questioning you. But here's what most people don't know. There's a version that applies specifically to kids. In 2011, the Supreme Court decided JDB versus North Carolina. When the Supreme Court has a case, or when the courts have a case and it's a minor, they always use the initials. So JDB is the initials of the teenager who was being charged at the time. JDB was a 13-year-old student. Police and school administrators, 4 adults total, 1 police officer, 3 administrators, pulled JDB out of class, brought him to a closed conference room, and interrogated him. No Miranda warnings given, no parents were present, no lawyer was called. The Supreme Court said this was a problem. So one of the ways we figure out if you are detained or not is would a reasonable person in that situation feel like they could walk away from the police officer. So if a police officer comes up and asks you a question about something you've seen, are you detained or can you walk away? Well, a reasonable person would say you don't even have to answer the police officer's questions. You can just walk away. So you are not detained. If you are in handcuffs sitting in the back of a police vehicle, right, with the doors closed, you probably don't feel like you can get away. And so you are probably detained in that situation, depending on what the other facts are. So would a 13-year-old feel like they could get up and walk away? Of course not. 13-year-olds are going to react to authority, especially with 4 adults in the room. So the court said that's not realistic. So there needs to be some guidelines in place to protect that 13-year-old and any kid, right? What's interesting is there are 2 levels of government in the United States. There's the federal government, and that's out of Washington, D.C. with the president, the Supreme Court, Congress. They make laws for the whole United States, but they can only make laws in the areas that the Constitution allows them to make. Then there are state governments. So we have federal and state governments. The state government make laws for everything that's within their border, and they actually have more control over the people than do federal governments because they're closer to the people. That's the idea there. Right now, states across the country are passing laws that go further than what the Supreme Court requires. California's law requires a private consultation with a lawyer before the teenager can waive their rights, and every interrogation has to be recorded. So what you've got here, there's a tension going on between the police doing their job and people having their rights. The police need to find the bad guys that are doing the thing that harms society. That's what crimes are. Right? That's what they're trying to do. So we need to give them the ability to do that. At the same time, we don't want the police to abuse their power, which is why when it comes to teens, teens are more susceptible to authority in general, and so we protect them more. And so you cannot just have a teenager in with a police officer without some clarity, without some support. And in some states, they are adding the fact that you need a lawyer or need to consult with a lawyer before you can actually waive your rights. Why does this matter so much? Because studies show that roughly 90% of juveniles still waive their Miranda warnings, and teens make false confessions at a dramatically higher rate than adults. These new laws exist because the old system wasn't doing its job. So what should you take away from this? If you, as a teenager, ever have to be questioned by the police, use your rights. Right? You have the right to stay silent and you have the right to an attorney. Use both. Say, I want an attorney, and then just close your mouth. You don't have to say anything. Let's move on to right number 2, the Fourth Amendment in schools. The Fourth Amendment secures you against government intrusion in your person, your houses, your papers, and your effects. Okay? Against unreasonable searches and seizures. So that's the key part. Unreasonable searches and seizures. So that means if it is a reasonable search, then the police do not need a warrant. If it is an unreasonable search, then the police need a warrant. But does this protect you in school? The answer is yes, sort of. So in 1985, the court decided a court case called New Jersey versus TLO. So a teacher caught a student smoking in the bathroom, which obviously is against the rules. An assistant principal searched her purse and found marijuana and evidence of drug dealing. The student argued that the search violated the Fourth Amendment. So when it got to the Supreme Court said that school officials do not need a warrant and don't need probable cause to search you. They only need reasonable suspicion. So reasonable suspicion is the lowest form of evidence against somebody. You've probably heard of these burdens of proof. Reasonable suspicion, probable cause, there's preponderance of the evidence, there's clear and convincing evidence, and then there's beyond a reasonable doubt. Beyond a reasonable doubt is what you probably are most familiar with. That is the burden of proof that the government has to use to prove all elements of a crime to take away life, liberty, or property in a criminal case. Okay? Reasonable suspicion is like barely anything. It's more than a hunch, right? You can't use like the force to decide somebody has, you can't use the force to decide if somebody is doing a criminal activity. You have to have some objective facts. That's what a reasonable suspicion is. But there are still 2 rules that the search has to follow. It has to be justified at the start, and it has to be reasonable in how far it goes. The second part is critical. In Stafford v. Redding, 2009, school officials strip searched a 13-year-old girl because another student said she had ibuprofen. Regular, over-the-counter ibuprofen. The Supreme Court said that this was unconstitutional. The seriousness of what they were looking for did not match the invasiveness of the search that they did. Now, there's an open question that the courts are still fighting about when it comes to school resource officers. SROs. School resource officers are SROs. SROs are police officers stationed in schools. When an SRO searches you, are they acting as a school official, right? An administrator, a police officer, an administrator or an assistant principal, something of that nature? Meaning that they only need reasonable suspicion, or are they acting as law enforcement officers, which means they need probable cause? Probable cause is a higher level of evidence than reasonable suspicion. The Supreme Court hasn't given us a definitive answer yet. Remember, this is what happens. The Supreme Court's there to interpret the laws for us. The Supreme Court is a passive institution. The Supreme Court does not go out looking for laws that it needs to interpret or fix that might have some issues. It has to be brought before them. All right, so that can take time. It can take effort. It takes a while. The Supreme Court hasn't given us a definitive answer on the SRO topic. Most state courts say SROs are like school officials and apply the lower standard. But some courts say that when an SRO is acting in a law enforcement capacity, like investigating a crime, the higher standard still applies. This is a huge deal, and it's one of the unresolved questions in education law right now. Again, this is that tension. This is a huge deal because we're trying to figure out, okay, we want the police and we want the administrative officials to be able to protect the students as they need to be protected, but we also need to protect individual rights of students. We don't want them to go, the school officials, to go too far. So here's your takeaway. Schools can search you. Schools can search you with less justification than police on the street. But they don't get to just search you just because. And they can't go further than the situation warrants. You got to understand the difference there. Right number 3 is about teen employment rights. If you have a job or you're about to get one, there are federal laws that limit when and how much you can work. This is an interesting one. Under the Fair Labor Standards Act, if you're 14 or 15, you can work a maximum of 3 hours on a school day and 18 hours during a school week. Your hours are restricted between 7 a.m. and 7 p.m., except in summer when the cutoff extends to 9 p.m. If you're 16 or 17, there are no federal limits on hours, but you're barred from the hazardous jobs. Those are the rules. But here's what's actually happening in the real world. In fiscal year 2024, the Department of Labor wrapped up 736 child labor cases involving over 4,000 children and handed out more than $15 million in penalties, an 89% increase from the year before. As of January 2025, the Department of Labor had over 1,000 open investigations. Some of these cases involved children, including unaccompanied migrant minors, cleaning meatpacking plants in the middle of the night. And states are going in a completely opposite direction. On one side, states like Alabama, Colorado, Minnesota, and Virginia strengthened their child labor protection acts in 2024. California, Utah, and Minnesota passed new laws protecting minors who work as social media influencers. On the other side, Indiana now lets 16 and 17-year-olds work full adult hours without parental permission. Iowa allows 14-year-olds to drive alone up to 25 miles to get to work. It's a little bit terrifying. Florida has proposed eliminating meal break requirements for minors. Since 2022, 12 states have weakened their child labor laws. So the idea, there's something going on here. There's a tension between the federal labor laws or just the laws in general saying, hey, we need to protect our children. But then there's also kids need to learn responsibility. Some kids want to work, some kids want to have money. Now, when I was young, I was lazy, I played sports, and so I worked a little bit. My sister, though, she's much tougher than I am. She worked all the time, and she learned a lot from doing that work. Like, it built a lot of who she is because she worked hard and learned that at such a young age. So there's pluses and minuses here. And really the question becomes, okay, who gets to decide? Is it the kid? Is it the parents? Is it the government? And that's a constant tension that we are seeing in our society. So your takeaway here, know your rights before you start working. Federal law sets a floor, but your state law might give you more protection or less. Look up your state-specific laws to figure this out. In 1969, the Supreme Court decided a case called Tinker v. Des Moines. It is a very important case when it comes to the free speech allowed within schools. So the students in Tinker v. Des Moines, there were a few of these students, they decided they wanted to protest the ongoing Vietnam War at the time. And what they wanted to do was wear black armbands. And they were going to wear them to school. And all they were doing was saying, hey, we don't like the Vietnam War. Well, we have the right to protest in this society, right? A free society has the right to protest. Part of what free speech does, the largest part of free speech, is to be able to criticize the government. So the question is, can these students do this in a school setting? Well, the administrators got word that this was going to go on. And so they got together, and a couple days before the protest was about to happen, they created a rule that said you can't wear armbands at school. If you were, you're going to be sent home and you're going to be suspended. Well, the students still wore the armbands. There was a little bit of a dust-up at school, not too much, but there was some conflict, some between teachers, some between students who didn't like the armbands, and the students were sent home. Well, the parents decided to sue before the school could punish them. This happened around the Christmas break, and so students, they did the protest a couple days before the Christmas break, and so they weren't missing a lot of school over the Christmas break, and the parents stepped in so the school would not punish them further, and it went up to the Supreme Court. The school said that the suspension was unconstitutional. Now, they created, this case is where you get the famous line, students do not shed their constitutional rights at the schoolhouse gate. This is an interesting case, okay? So the rule from Tinker is that schools can restrict your speech if they can reasonably forecast that it will cause a material and substantial disruption. Not just an annoyance, not just a disagreement, actual disruption. Now, this is interesting because this creates an interesting tension within me because I'm a free speech advocate, but also as a teacher, we're there to do a certain thing, right? We're there to learn. As a teacher, I'm there to teach you the concepts. As a student, you're there to learn the concepts, and we're trying to make you a better person and make you more productive, whatever it is that we're trying to do in that class. And so I don't know if that's actually the best place for you to speak your political views. They said that students do not shed their constitutional rights at the schoolhouse gate, right? And it's got to be a material and substantial disruption. Now, the word material in law means like really big, right? Material and substantial disruption. So it can't just be a minor disruption, right? It can't just be an annoyance. Now, over the decades, the court has carved out some exceptions to this. Schools can restrict vulgar or lewd speech. That's from a Bethel v. Frazier 1986 case. Schools can control what goes in school-sponsored publications like newspapers, which comes from Hazelwood v. Kohlmeyer 1988. I might have said that last word incorrectly. And schools can limit speech that promotes illegal drug use, which is Morse v. Frederick, 2007. So there are some things that the school can do, right? Again, it's an environment for learning, and we're not trying to have constant disruptions going on. But what about speech that happens outside the school? Now, this is becoming more interesting as technology develops, as students have access to phones and social media and things of that nature. The schools, again, a material and substantial disruption in the environment of the school. But as soon as you leave the school, what power does the school have over you? Well, in 2021, the Supreme Court took up Mahoney v. BL. A 14-year-old cheerleader didn't make the varsity squad. That weekend, off campus, she posted a Snapchat rant with some choice language about the school. The school suspended her from JV cheerleading for a year. So this is an interesting case. So controlling language, disrupting the school, these are all kinds of things that are important for a school to be able to do. But this was on the weekend off of campus. Well, whose job is it to discipline the cheerleader, if anyone? Is it the schools? Is it their parents? Right? And here they said the Supreme Court said that the school went too far. They ruled that schools have a diminished interest in regulating off-campus speech. You can still get in trouble for things like genuine threats, severe harassment, or cheating, but a frustrated post on your personal social media made away from school, that is protected. Right? Protected means government can't interfere with it. They can't come up, they can't punish you, they can't make rules about it, things of that nature. If it's unprotected, they can punish it, they can make rules for it. In early 2025, a federal appeals court. So an appeals court is the level right below Supreme Court here, appeals court here, district court here. Districts are where you have the trials. Appellate courts are where you have 3 judges, sometimes more, but usually it's 3 judges and lawyers arguing about the law. And then the Supreme Court has 9 justices and just lawyers and justices arguing about the law. There's not a real trial there, though there are times that can happen in the Supreme Court. It's not usual that happens there. In early 2025, a federal appeals court reinforced this in Leroy v. Livingston Manor Central School District. A student posted an off-campus image that the school found offensive, and the court struck down the discipline. Offensive content alone, without strong evidence of actual disruption, isn't enough, right? And this is common within free speech. You do not have the right to not be offended. When we talk about offensive language, it's not the law. It's not the government that gets to choose what's offensive or not. This is more of a social issue, meaning your parents, your community, they put the pressure on in non-legalized force ways. That's what government is. Government is legalized force. And so being offended is not something that's protected. You don't have the right to not be offended, right? Because we don't want the government to pick winners and losers. And so now you can be socially pressurized. Your parents can tell you to knock it off. Your community can ostracize you, but the government can't come in and limit you. Okay? Now, here's another area that's evolving as we're talking about this. One thing to watch, over 17 states passed cell phone bans in schools during 2024 and 2025. Those bans are raising new First Amendment questions about whether restricting access to phones also restricts students' access to expression tools during the school day. So that one is evolving, and that one we may have to do a video in the future when that shows up. Here's your takeaway. You have free speech rights at school, but they have limits. Off campus, your rights are stronger, but not unlimited. Think before you post, but know that the Constitution has you back. Let's talk about right number 5, digital privacy. The main federal law that's protecting kids' privacy online is called COPPA, the Children's Online Privacy Protection Act. But it only covers children under 13. It only covers children up to the age of 13. If you're 13 or older, COPPA doesn't actually apply to you. So the Federal Trade Commission updated COPPA's enforcement rules with changes that took place effective June 2025, but the core age limit hasn't changed. So Congress is trying to fix this as we speak, or as I record this video. There's 2 major bills that have been introduced and reintroduced multiple times. There's 2 major bills that have been introduced and reintroduced multiple times. So a bill is what you have to go through Congress before it becomes a law. First there's COPPA 2.0. This would raise the protection age to under 17, ban targeted advertising aimed at minors, and create an eraser button that lets you delete your personal data. It passed the Senate 91-3 in July 2024. That's almost unanimous. I mean, that's shocking, quite frankly. But it stalled in the House. It was reintroduced in March 2025. Second, the Kids Online Safety Act, or called KOSA, K-O-S-A. This would require platforms to exercise a duty of care towards youngsters. A duty of care is a legal obligation. Okay. This means that there is, depending on what the standard is when they put in this law, you have a reasonable duty of care. Think about a car. You have, if you are driving a car, you have a reasonable duty of care to the other drivers on the road. Texting while driving gets in the way of that, and so you shouldn't do those kind of things, and you can get in trouble for not exercising the proper duty of care. KOSA also passed the Senate 91-3, but it also stalled in the House and was reintroduced in May 2025. So while Congress figures itself out, states are stepping in. Remember, we have federal governments versus state governments, right? New York passed the Safe for Kids Act in 2024, which bans addictive algorithmic feeds for minors without parental consent and blocks late-night notifications. Teens need that kind of thing, right? New York also passed the Child Data Protection Act, effective June 2025, which prohibits collecting or selling minors' data. Tennessee now requires parental consent for all social media accounts for anyone under 18. Connecticut banned features designing to keep minors scrolling, like infinite scrolling, effective October 2024. And as of January 2025, 19 states require age verification for certain types of online content. So what you're seeing here is when the government steps in, that limits the choice that we have as citizens. Okay. In this instance, they're saying, in the various state laws that we've just talked about, they're saying parents no longer have the choice to allow this or not. We've decided as a government, and the government does have the right to come in and take care of public health and general welfare, right? They have a vested interest in making sure their citizens are protected. This is why you are forced to wear seatbelts. Seatbelts are a smart idea regardless, but that's why they can punish you for those things if you don't wear them, because the government has a vested interest in seeing its citizens protected. And so with kids, we ought to be more sensitive to this. And these are governments coming in and saying, listen, we know that these are negative effects. We're learning about these negative effects of social media and how it affects students and the well-being of our citizens. So we're going to put these laws into effect that stop our most vulnerable citizens, children, from being taken advantage of. That's what these are all about. So your takeaway is that the law is catching up with technology. And that's a slow process, but it's not there yet. Right now, your best protection is understanding what data you're giving away and to whom. Pay attention to what your state is doing. The rules are changing fast. Those are 5 legal rights you have right now as a teenager. Miranda rights, search protections at school, employment protections, free speech, digital privacy. The law treats kids, teenagers, children, differently than adults. Sometimes they protect you, sometimes it doesn't protect you enough. The first step is knowing what rights you actually have. If you learned something today, hit subscribe. Here at Law School for Teens, we break down legal concepts specifically for teens, because understanding the law shouldn't need a law degree. I'll see you in the next one.